Hello everyone, welcome to this week's whistle-stop tour of the news because there is a lot to get through. Apologies in advance that I will be partially reading from my laptop today because there are too many news stories for me to memorise like I usually do. So let us start off with Allen&Overy's big news. They have revealed the new cohort of startups to be housed under the warm wing of their Fuse incubator. As you probably know, Allen&Overy has a tech startup within it which spawned the likes of Kira Systems, no big deal. So when they announced the new cohort, we're all interested. So who is going in this year? APAX, a startup which builds tools aiming to create machine-readable rules, thus enabling customers to access complex financial regulations on a digital basis. 2. Define, a drafting tool which helps users to access defined terms and references in documents more easily with the intention of speeding up the drafting process. 3. Cicero, a legal AI platform that reads, drafts and marks up legal agreements on an automated basis. And 4. Spot the odd one out. HiQ, nothing like a startup. A platform which seeks to provide social collaboration, secure file sharing and project management with the aim of improving efficiency and productivity. HiQ also used by many of the major law firms and was developed, I think, almost 10 years ago. So I suspect there is slightly more to the relationship with HiQ than meets the eye from this article, but I don't know what it is and I'll keep you informed if I find out. On the subject of Fuse, the Fuse manager Shruti Ajitsaria has recently been promoted to partner in the latest round of partnership promotions. And that's kind of cool because actually it's quite rare that non-fee earning lawyers actually make it to partnership level, but it just goes to show how much importance Allen&Overy place on their innovation structure and the people within it, and she's done some amazing work heading up Fuse, so she fully deserves it and I'm really happy for her. On the subject of HiQ have also just announced that they've entered into a deal with BPP Law School to provide services to their students. HiQ's website says the partnership with BPP allows students to explore new ways to use technology to serve clients and deliver legal services with value and efficiency in mind. With experience using leading technology, BPP students will have the skills to embrace innovation for the entire span of their legal careers. So if you're going to BPP, you can look forward to engaging with HiQ, and it will also really prepare you for a lot of the law firms which are using and engaging with HiQ regularly, so you'll be a step ahead of everyone else if you already know how to use it. Next, fixed recoverable costs in civil litigation. Lord Justice Jackson continues his crusade, even in retirement, to limit the costs of pursuing civil litigation claims. So this started back in 2013 with his first tranche of reforms, which introduced fixed recoverable cost brackets for claims at the lower value end of the spectrum. And the second tranche is intended to introduce fixed cost brackets for those claims up to £100,000. Now, I can understand this to an extent. I read yesterday the NHS paid out over £600 million worth of legal fees in last year alone for negligence cases. So I can understand why Lord Justice Jackson wants to put a cap on those fees to prevent them from getting out of control, and also to make sure that it creates access to justice, because the cost of litigation does prevent some people from pursuing claims. Incidentally, the cost reforms are not intended to cover clinical negligence claims, but no doubt they will in the future. Anyway, the flip side of that is if you limit the recoverable costs at each stage of civil litigation, what you're essentially doing is limiting the amount of work that lawyers can do and the amount of investigation that lawyers can conduct into your claim, because lawyers are not often in the business of working for free. So essentially, once we reach the costs cap, we cannot continue to do work in that particular phase because we're not going to get paid for it. So what essentially that means is that we then have to stop investigating. And if there's something that's particularly significant, for example, if you're in a personal injury claim and it transpires that there's an additional injury that's identified somewhere throughout the lifetime of the claim, that injury may go uninvestigated because we simply don't have the costs available to us to pursue it. So at the front end, you're facilitating access to justice because potentially more people can now pursue litigation than could do before because it's more cost effective. However, at the back end, you may potentially be prejudicing those claims because of the lack of investigation. What I'm picturing right now is a sausage dog with one of those cones that you get from the vet. But listen, I'm seeing all of this access to justice at the front end, with more people being able to engage in civil litigation than potentially were before, although all the injury clients were likely on no fee agreements anyway, so it doesn't make that much difference to them. But anyway, you have all this access to justice at the front end. However, as you move through the lifetime of the claim, the justice is gradually getting squeezed out all the way through until you end up with this stump of justice at the end. And there you have the sausage dog of justice. Right, what am I actually trying to say here? What I'm trying to say is that I understand what he's trying to achieve here. Having read the full 50-something page proposal, it actually makes a lot of sense, and he's thought of a lot of negative consequences, and he's tried to combat them and create exceptions where necessary in order to make sure that some of these injustices don't come to fruition. However, I feel that the proposal may create as many injustices as it's intended to remedy, at least for the time being, whilst lawyers are still people and we haven't been replaced by robots which are able to do the same amount of work in half the amount of time. Maybe my next project should be making a robot version of myself so I can retire once it's complete. But in a much more real way, law firms need to become more efficient. I've been saying that since day one of LAB. We need to be able to do the same amount of work in less time in order for access to justice to be facilitated in the face of fixed costs. Mic drop. Next on the agenda, bundles. Bundles have been the subject of much fun on Twitter in the last week because there was recently issued new guidance which said that all contents and bundles had to be printed double-sided, which is news because normally they have to be printed single-sided. If you are a junior lawyer and know the pain of bundling, then you will identify with this massively. If you have yet to enter the realms of practice, then you have all of this joy yet to come. But either way, this Twitter storm was instigated by Gordon Exel, who I've mentioned previously for his fantastic blog, The Civil Litigation Brief. He started off by asking his Twitter community whether they had any advice for junior lawyers when it came to bundling, and a lot of the responses are really funny but also really helpful. So if you are interested in the bundle fiasco, then head on over to his Twitter page and have a look at what was going on last week, or just go on to the Civil Litigation Brief and read his blog on it, which is one of his most read blogs ever. So well worth checking out, and he's also posted more and more stuff recently which is aimed at junior lawyers and helping them through the process. So definitely check out his page. Next up, are you still confused about how the SQE might apply to you? Well, be confused no more, because Barbary have released the SQE calculator. Essentially, if you put your details into this calculator, it will tell you what options are available to you. I will link the link in the description below so that you can go to it and you can put in all your circumstances, when you're entitled to graduate, whether you're a GDL student, etc., and it will tell you what your options are. Next, gender pay gap. All companies with over 250 employees had to file their gender pay gap statistics by the end of March, and initial results show that 78% of companies are showing a gender pay gap. What does that mean? Any number of things. I've addressed gender pay gap in this video right here in detail, so I'm not going to go through it all again. But I can tell you that it doesn't mean that men and women in the same role are receiving unequal pay. That is not what this statistic is about, because that would be discrimination, which is illegal. But what it does show is that if there is a gender pay gap, then that means that collectively one gender is being paid more than the other, which tends to indicate that there is more of one gender than another in the more highly paid senior roles. But there could be a number of reasons for that. So if you are concerned about gender pay gap stats, I would always encourage you to read between the lines and have a look into the statistics and what they realistically represent, because every company will have a different reason for its gender pay gap. Next on the agenda, Ernst & Young. What are they up to now? First, the acquisition of Riverview Law, which I reported on last year, and now they have acquired the entire legal managed services arms of Thomson Reuters. Another massively disruptive move for one of the big four players. But what are they up to? The beauty of EY is that no one knows. This is the best marketing campaign of any legal entity that I've ever seen. Never mind all of these awards winners who produce amazing figures and ROI. This is the best marketing campaign of all time. EY reveals so little about their grand plans that it generates this insatiable desire and hype surrounding their plans for the future. So I don't know what they're doing, because neither does anyone else, but this definitely represents a massive move, and the chances are they do have some big strategic plans ahead of them, but it remains to be seen what they will actually do with all of this new legal services technology that they've acquired. safe to say that they are looking very dangerous, and no doubt the other firms in the Big Four and major corporate law firms will all be ever so slightly concerned about what their next move's going to be. Okay, last few rifling through now because I'm conscious how long this video already is. No fault divorce being introduced, which essentially means that going forward, couples will be able to file for divorce without blaming each other, which is intended to remedy all the hostility and conflict between parents and make things generally better for the children and the families combined. Remains to be seen how and when it will be implemented, but it's something you should be aware of if you're looking to go into family law or you're applying to firms which have a large family law practice. Final thing, Junior Lawyers Division Resilience and Wellbeing Survey results are in, and the results are sadly very concerning. One of the statistics reveals that 1 in 15 junior lawyers is having suicidal thoughts, which is totally unacceptable. I'm not going to talk any more about mental health in this video because it's already too long, but I can tell you that I will be tackling this in a slightly different format at a later stage, so watch this space. Okay, that's it. Thank you very much for listening. Sorry it was so long. Catch you same time next week. Bye.